John. And then Winnie D.
My name is Jonathan Osorio. I'm a professor of Hawaiian Studies at the University of Hawaii, Manoa, and a board member for KAHEA of the Hawaiian Environmental Alliance. KAHEA calls for the repeal of Act 55 and believes that there are no rules that can alter the intent and foreseeable outcomes of this legislation. Act 55 is designed to allow commercial interests and even government officials to circumvent or even ignore state and local regulations that would otherwise apply. And, you know, one of the things that we have in place in Hawaii after many, many years of struggle are regulations, regulatory agencies that have been put in place really to protect and to conserve our natural resources. Some of these have been in place since before we became a state. More recently, the state has begun to recognize the unrelinquished claims to the lands by Native Hawaiians. And basically, all rules notwithstanding, this act will produce new opportunities for a taking of ceded lands, whether through outright sales and transfers or through long-term leases that might just as well be sales. And Hawaiians will sue. In fact, I think that the ultimate product of Act 55 will be endless litigation and a deepening mistrust of state government that cannot seem to manage our resources and cannot really plan effectively for the future. I will speak now as a Hawaiian Studies professor. We are deeply concerned about the future economic trends of the state. And we believe that important and daring new kinds of developments need to take place, in particular in the areas of agriculture and sustainable agriculture and food security. We do not believe that this legislation produces that. In fact, it produces just the opposite. I feel really sorry that a few legislators can come up with harebrained legislation and leave you folks here to take the brunt of public discourse. What you are seeing here tonight is a referendum on our deep lack of faith in this government. And I hope you convey that to them.
And then after Winnie D, Dean Kapeluto.
Mr. Haraguchi, Ikeda, and Aila, what would you call a person who reneges on an agreement to build 750 affordable homes on land that was given to them free by the state? The answer is the corporate person, Castle and Cook Homes. And that's just a recent example of a public-private partnership in which the private developer says, oh, we couldn't make a profit, so we couldn't do this public benefit that we promised. And the state says, oh, you poor thing, okay. There's no public recourse. Corporations have a duty to make the highest profit they can for their shareholders. And so, I'm not a lawyer and I don't know how to state the administrative rule that is needed. There needs to be a rule that imposes this huge financial penalty so that someone like Castle and Cook Homes can go to their shareholders and say, oh, we had to build those affordable homes for sale or rent, even though we lost money because we would have had to pay a huger financial fine and lost even more money. That's the only thing corporations understand. So put that kind of language in. I attended a HEART board meeting and PLDC is a joke. Your colleague, Robert Bunda, sits on your board and the Honolulu Authority for Rapid Transportation, which is weird. You know, why is he on transportation board, your board, and why does HEART ask for a report on PLDC at their meeting? And all he did was Mr. Bunda just mumbled something I couldn't hear, and everybody laughed. All the board members laughed. It was an inside joke, but I did hear somebody say, oh, what is it, top secret? And they laughed some more. Now, I wasn't laughing. And I'm afraid the joke is going to be on the public, people like me. The only people laughing about PLDC are the people who are laughing all the way to the bank, the financiers, the developers, the profiteers off of this. We need to have some rules so we are all happy. The public is happy. We need a fair deal. Public is never going to get a better deal from corporations. It's like me trying to get a better deal from the car dealer. I don't think so. That's their job. They're going to get the best deal from me, from the public. You need to make some rules so we can at least have a happy, fair deal for all of us. And last comment, why would HART ask for a report on PLDC? It has to do with transit-oriented developments, and I'm explaining for the people who don't know. Okay. It's because 20 miles of rail line is owned by city or state. It's public land. PLDC is to enable the development, high-density, mixed-use, whatever it is, in the transit-oriented development areas. Thank you for listening to me.
And then Barbara Polk.
Aloha. I am Dean Kalani Kapaluto. I'm from Kapolei, Makakilo. Just going to comment about the draft documents that we're supposed to be talking about tonight. There's a comment in the document. It talks about managing and creating revenue centers or exploiting potential local, national, international markets. And the key word here is exploit local markets. Do you think we really want to be exploited? Do you think the Hawaiian people want to continue to be exploited? I don't think so. I take exception to that term, exploited. But it's probably closer to the truth. Our people and lands are being exploited. Who wrote this? The PLDC is supposed to be culturally sensitive? You guys didn't listen to OHA when they gave their draft documents? I don't get it. I don't think so. This program is supposed to encourage development that is culturally sensitive. You mean like the rail program? This, which began construction without having the surveys completed in advance. Is that what we're talking about? Encouraging economic development that is culturally sensitive? Because to me, that sounds like a fat lie. And the state Supreme Court agrees. The term eligible developer in this document sounds to me like another term for constructing another good old boy network. I don't like the fact that they can consult with local neighborhood boards and communities, and that the local neighborhood has absolutely no power to say no. We don't want this in our backyard. Our neighborhood boards and communities need the power to have a say of what goes on in their community, what goes in and what stays out. And this corporation takes the power and the will of the people away from them. Why should a corporation of appointed good old boys have the power to tell the community what is going to happen with their land? That land is a public trust, ceded lands that belongs to the Hawaiians. Sorry, but this is not Pono. One comment they mentioned earlier about the difference between terminology may and shall. I want to point that out as that's important. Since when do people that have not been elected have the power and authority to issue out revenue bonds, which must be repaid back by the taxpayer at a time later in the future? I got about 8 pages here, but I'll condense it. If you fail to make a payment Now they have the power to sell your private property. That's serious constitutional issues involved here. Isn't this the mother of all land grabs in the history in the state of Hawaii?
Yeah. Yes.
This PLDC seems to be the opening of a new chapter in the corruption of local politics in Hawaii. What assurances do we have that this corporation will not initiate pay-to-play tactics in the development of projects? There are just too many questions and possibilities for the PLDC to abuse the people of Hawaii and the lands that were entrusted to the people, not a bunch of special interests. As a corporation, there should be shares on record of who owns the corporation, and those stockholders should be the Hawaiian people and the public. And we should have a vote in who's the directors and who's on this board. There are some clear constitutional issues with how this corporation was formed, and I would say, in my opinion, that the establishment of this corporation violates the Hawaii State Constitution, which indicates that we must be mindful of our Hawaiian heritage. Nothing in this organization document leads me to believe that this key point of our Hawaiian Constitution is being adhered to. In fact, I think our Hawaiian Constitution is being trampled on, yet again in favor of special interests and developers. This is a travesty of epic proportions, and we need to hold our elected officials who voted in favor of the PLDC, because this is not good for our community, it's bad for our children, it's bad for the future of Hawaii, and it's bad for local Hawaiians. I say no, Act 55 has to go.
Thank you.
Again, I'm Dean Kalani Capiluto. If elected to State Senate District 20, I pledge to repeal Act 55.
After Barbara Pope, Keiko Bong. Keiko Bong.
Hello, I'm Barbara Polk. I represent Americans for Democratic Action, Hawaii, ADAH. I have a couple of extra copies of my testimony. ADAH strongly objects to Act 55 and will work to repeal it. However, we realize in the meantime it is the law, and that the PLDC exists, and that you are currently looking at a minimum of 6 different projects, any of which might be approved prior to the legislature meeting again. And so for that reason, we want to address some particular things. We've only looked at this point at Chapter 302 of your regulations, and we'll make comments on those. In the first place, we're concerned that in the purpose, please add the words, while ensuring that the public land is maintained for the people of Hawaii. That's part of the requirement of the Act. We're also concerned about the status of Native Hawaiian culture and sensitivity to cultural practices. We think that needs to be strengthened in several areas. One of them is on page 12 at the bottom. Current wording says encourages development that is sensitive to cultural or historical resources, etc. Encourages isn't the right word. It needs to require it. That's what you are required to do under the law, not just encourage it. We would encourage you to add to this portion of the rules Article 12, Section 7 of the Constitution, so that it will remind you and remind any developers who want to work with you of the commitment by the state to the Hawaiian people. We also noticed that on page 14, the corporations required by law to approve only culturally sensitive development, the sentence, this is with regard to proposals that come in, the requirements for the proposals, the extent to which the proposed project is culturally sensitive is one of their requirements. That should be deleted and replaced with the specific ways in which the proposed project will be culturally sensitive, and the verbatim comments received, if any, whether orally or in writing, that question the cultural sensitivity of the project. These are things that the board really needs to look at specifically. We're glad to see that there is a provision for one public meeting. We think that is not nearly enough. that there probably should be a minimum of 3 public meetings. It's also unclear as to when those public meetings are going to be held. That needs to be clarified, whether before the proposal comes in, afterwards, and who holds it. Finally, notification of pending projects. There's not really a provision for notifying the public of pending projects, and we believe that within 10 days after the acceptance of a proposal is complete, information about that project should be published on your website and in newspapers, so that people have an awareness of the things that you're looking at and can begin to think about them. Otherwise, a hearing is announced and there's very little time to deal with it. We have a couple of other specific suggestions which I'll not discuss at this time, and we'll probably come in with some more later. Thank you very much.
Know as I kick this flows in my verse to oppose